Good morning, good afternoon. Hello, everybody. My name is Jason Weiss. You are listening to the Ask Jason Weiss show. I am an attorney who is moving towards the direction of full-time coaching. I'm just going to put this disclaimer out here that anything that is discussed today is not legal advice. You are not hiring an attorney. There is no attorney-client privilege between myself, you, or our guest, who is the one and only John Bradley, who is here today with us. So this is no legal advice and nothing here. So what I want to do is I want to introduce Mr. John Bradley. I've known John Bradley, and when I slip and call him JB once in a while, I will apologize, but I've known John for close to 20 years. When it comes to anything, he is one of my go-tos, and I ask questions, and just a phenomenal attorney and an even better man. But he is here today to talk about, he is truly a rock and roll attorney. And I mean that by he rocks, he rolls, he's awesome, but he is truly in that rock and roll and music space. So without further ado, no one wants to hear from me. JB, give us a 30-second intro on yourself, and I'm going to start asking you some questions, and we'll be rocking and rolling.
It'll be good, Jason. It'll be good. So my best badge of honor is Jason is my dear bud. But for some reason, after 40-something years of playing music and all, I've done 33 years as entertainment attorney, music lawyer, rock and roll lawyer. And I am one of the few people left standing today that can say that they have made their entire life and career on the rock and roll business. And it's been a pretty good time. Pretty good time.
And that's pretty amazing, because especially here in South Florida, you hear from attorneys, including myself, I admit, I am a sports and entertainment attorney. And what does that mean to some people in the industry? It could mean that, hey, my next door neighbor is a professional baseball player and I did the closing of his house. Now I'm a sports attorney. It could be that, hey, I represented a musician in a speeding ticket. Guess what? Now you're a music attorney. But JB is honestly a music, entertainment, dabbles in sports as well, but he is the rock and roll attorney. And what do I mean by that? I mean, he's in there. He's been doing 360 deals. He did merch deals. He did all this stuff. And that is this guy. And JB, I don't know if you're comfortable talking about client names. If you are, cool. If you're not, please don't. But tell us, how did you find your way into the music industry?
Well, for me, I've been a musician since I was a kid. And so that's
what instruments?
Let's see, guitar, ukulele, bad mandolin, bad bass, bad piano, reasonable vocals, writing, recording, record labels, and lawyer. That's all.
All right. So since a kid, you've been strumming the guitar, and then I interrupted you.
No, I've been playing out in front of people since I was a young teenager. First band with my dad, I think at 12 or 13. And so I got to do that and do all of the stage stuff before we even finished law school. Did have an awesome rock and roll band in law school, so all of the law students would come out every Wednesday night, and we would drink cheap beer at the local hall downtown. And getting out of school, I worked for a solo practitioner who put me to work hard right away. And when I brought up to him, I want to try to chase some of this music stuff, he said, that's fine with him as long as I did it after hours, after I did all the work that he gave me. So, I learned what I could all by myself, and, went to the rock and roll shows and all of that, and met with clients and figured that out for myself. Today is a different story. Man, they teach entertainment law in law school. Not when I went. No. There was, I think there might have been a copyright class that I didn't take. That's on me. But I don't remember any other IP stuff in school at all back then. And now there's copyright, there's trademark, there's a couple of schools like UM that's got some parallel program with their undergrad degree, and that's awesome.
Yeah, and University of Miami and Nova, they both offer also sports. It's not even just sports and entertainment. Sports, entertainment, intellectual property. That's 3 classes. That's awesome, and it shows how long of a way we go, and which segues into a perfect question. You talked a little bit about copyright and trademark, and you did not mention patent. For those people that are musically inclined that do not know the law as well as someone like you, can you just give a quick 2-minute synopsis of what's the difference between a copyright, a trademark, and a patent? Because I can tell you all the time, I'll get phone calls from musicians and, hey, I wrote a piece of music and I want to protect it and I want to get a patent and a trademark and a copyright. And I'm like, whoa, time out. You don't need them all. So I guess start with patent, since that's the one that doesn't really apply, and then move into the other 2.
Gotcha. Okay. So a patent generally is a useful device, something that does something. And so that doesn't fall into the entertainment space per se. You can have a design patent, which might be the look of a dress, the way that the flaps fall, something like that. Again, not falling into the art space generally, except for the clothing and merchandising industry. So generally,
or like a device that you add to a guitar, let's say.
Sure, something mechanical or electronic might fall into that space. But in terms of the creative type spaces, as we would call them, you're looking at copyright and trademark. Copyright and trademark are the keystones to all of the entertainment business, sports included, because make no mistakes, the sports industry is an entertainment industry. So in that world, we all deal with the basic core intellectual property issues, and then we build relationships and contracts and hopefully monetize them for our clients. So the first set you talk about are copyrights. In the entertainment world, you deal with, in a song, for instance, there are 2 copyrights. One of them is in the words and music. Mary had a little lamb, G, A minor, D. You can write that down on a piece of paper. Boom. Assuming it was original, you could get a copyright in that. But when you take a song like that and you go into a studio or pick up your iPhone today to record it, that recording can have its own copyright. So in this piece of recorded music, there's 2. There's one in the underlying composition, and there's 2 in the sound recording. Traditionally, in a record company artist relationship, the record company would be the one that owns the sound recording, and the writers of the song, or their publishing companies, would own the underlying composition. So that's the basics of copyright. Of course, if you paint a painting, it's a different type of copyright, but it falls under the same law. Trademark law is different. Trademark talks about a mark under which somebody provides goods or services. Coke, bottle of soda, okay? Nike, merchandise, sports-related gear. STP motor oil for old people talks about, the name under which someone provides, in this case, of goods. But in the case of services like a live concert, Foo Fighters would have a trademark or a service mark in the name Foo Fighters for providing live musical experiences. The process by which one creates them, the copyrights versus trademark, is a little bit different. And the process by which you protect them is a little bit different by registering them with the lovely folks in Washington. So that's, 3 minutes on a graduate and law degree in IP.
So when I first started practicing law, I was in I was an aspiring sports and entertainment attorney. And I remember I had one of the first clients come in that was a musician and a rapper, and he wrote his own stuff. And I'm like, did you copyright your lyrics? Did you get a copyright? And he goes, well, yeah, I did. I'm like, okay, so how'd you do it? And he said, well, I wrote down all the lyrics and I put it in an envelope, I put a stamp on it, and I mailed it to myself. And it went through the Federal Postal Service. I opened it up, and now I have a copyright.
Ta-da.
True or false, Mr. Bradley?
False.
Why?
Mail it to yourself doesn't count. Whether it's on a tape or a CD or a USB or whatever you do, knock it out in Braille, I guess. It doesn't count. Our copyright law and the trademark law to an extent says once you, in terms of copyright, fix something in tangible form, make a recording of it, the law starts to protect you. That's great. If you want to increase those protections, you need to register it in a specific way with the Copyright Office. And they give you a very specific way to upload your MP3 or the picture of your painting or whatever it is, pay them their $55 and on you go. The beautiful part about doing that is you don't have to prove what you created and when you created it if there's a dispute later and somebody tries to knock you off. You would have to do that if you don't have a registration. But more so, by having a registration, an author gains two big advantages in court. Number one, the author can recover what they call statutory damages, minimum legal amounts for a violation of the copyright. That's nice because you don't have to prove how much you lost if you didn't have the registration. And part two, you're entitled to recover your reasonable attorney's fees for going to court. That's big because taking a case to federal court for a copyright case can cost you $400,000. So that $55 registration goes a long way.
And of course, we recommend using an attorney for that registration, correct?
We do. You know what I do a lot of times is I'll bring in a new client and I'll do what they need today. And if they need a string of copyrights, we'll do one for them and then show them what we did. And if everything else lines up exactly the same, they can do the others. But subtle changes can change that. For instance, if there's a bunch of co-writers or if somebody wrote the music and then somebody else wrote the lyrics. And so a lot of times, you know, we'll do one or two for a client and then they'll just call us along the way. Hey, we got a new one. This changed like this. What should we do? And, you know, you can knock it out in really short order. But to get it right, at least the first time or sometimes several after that, essential to use an attorney to do it. And it's not a lot of money either.
And that's something that you do, and they could contact you at what, 954-523-6160 and speak with you. And the website is www.bradlegal.com. And for any aspiring artist or even any established artist, you know, don't try to save pennies now when it's going to cost you nickels, dimes, quarters, and bills later on.
No, don't do that. And I think the key is you need to find somebody that's got significant experience because, Jason, as you said earlier, there's a lot of people that put the label on themselves of entertainment and sports lawyer. Hey, that's great. I don't demean any of them. And I started from the bottom up and I worked my way into now being 33 years out. I've been the chairman of the Florida Entertainment and Sports Law section, and I currently sit on the board of our National American Bar Association's Forum on Entertainment and Sports Industries. That's important because it's not my first rodeo on a whole lot of this stuff. And sometimes things that, you know, newer lawyers might miss or haven't experienced before, they don't get by here where we've seen this stuff and done it. So it's not to say that others can't, but I know that, you know, when I go see a doctor or somebody like that, I want the experienced one And then, maybe we can talk about something else with the young whippersnapper. But I like experience. It counts.
So that's interesting, because when I was talking with a colleague of mine who is in law school currently, and I told him that I was going to have you on the show, and he was all excited. He actually asked me a question because a friend of an uncle of an aunt of a whatever, the young and upcoming artist is paying for studio time, and has some studio time and is going in and getting things demoed and mixed and all of that. And there was some concern as to who would own that recording during that session. So I will clean up the question a little bit, and I will ask on behalf of the law school student who's hopefully listening today, if you go ahead and you go into a studio and you record a track or a demo, who owns what and who's entitled to what, assuming you pay for, I don't know, the studio time is $500. Okay, here's your $500. What does that $500 get you?
So unfortunately, there's not enough rules on the road there to tell the answer with any specificity, which is why the person in those shoes would want to go in there with a simple agreement that spells out those answers from the get-go. There was a case a long time ago involving George Thorogood, where somebody did the recording and somebody paid for it at somebody's studio, and George and the Destroyers played, but there was this guy and blah, blah, blah. Listen, every one of those stories can come out differently. The copyright law says that to transfer any interest in copyright, it has to be in writing. So if somebody claims that they own the creative product of another, there needs to be something in writing. I can say with 100% certainty that I have lived a very nice life based on people who didn't do the paperwork first. And it's only when the product means something after it's been created that people start to have different impressions on who should own what and whose pennies should go where. That's kind of invariable. So what the person does in that position is they come in with an agreement that spells it out. Here's the songwriters and here's their shares, and I've hired all of you people to do all of these things, and I'm going to pay you what I agreed, but at the end of the day, I own it. It's really that simple. I did an agreement that had, 4 or 5 people this week, and I finished it on one page. It's not that long or that complicated. So you need to get it done in the studio. And I've heard people say before, oh, don't bring me the paper into the studio, man. That just brings me down. That's not the artist vibe. Bologna sandwich. Listen, if you want to do business here, you have to treat it like a business. And in the entertainment business, there ain't no business without the business. So you get it done. And if you find out walking into the studio that there's a problem, that's great, because at least it's better than afterwards, because it's going to be a problem then.
Oh, yeah. Oh, yeah. So you talked something about that you're laying down tracks on your iPhone. Do you see the recording studios, I'm not talking for the established, people, but more for the up and comers? Do you see, recording it on your iPhone and then uploading it to iTunes as maybe the future?
Well, in a lot of ways, it's the present, depending on what somebody's doing, Jason. Tastes in music have and always will change, from how something could be very complex to less complex, to how much old school instruments are on something versus just computer stuff today. So, we have seen big hits that are created on a Mac computer and sung with one microphone into some interface, and away you go. Is that everything? Does that define everybody's taste in the future? It probably doesn't. Can I say that it's not getting easier to record outside of a classic studio? No, I won't say that either, because gear is getting to be cheaper, incredible to work with, and people, I think, at an even younger age are able to deal with it very successfully. But, I mean, is there a place for a Philharmonic behind an awesome singer? Yeah, there is. And, where is music going to go? I don't know. But I know that we have the ability to create it anywhere and digitally upload it to just an infinite number of platforms. So
let me ask you about that. So let's
yeah.
just say, because I have zero talent, so I'll use my daughter. She's got some talent and she performs a song, she does a dance, she does whatever, and boom, we pop it up on YouTube. Somebody uses her YouTube clip. Do I have any rights to stop them?
Well, that depends on how many rights you had in the first place. For instance, who wrote the song? Did she write the song, or did she sing a song that somebody else wrote? Those tell us about the rights in the underlying composition. Let's suppose that only she wrote everything. It was purely original and no one could ever challenge that. And no one else helped her write the song. Okay, now she's got a song. Video. Did anybody else, help in the creation of the video? Is there paper with those people? Are there performers in the video that are not on the underlying track? Did they sign off on their rights? Okay. Did anybody register the copyright in the underlying composition to begin with? Did anyone register the copyright in the sound recording, whether it's separate from the video or not? So you jumping through all of those hoops. If somebody grabbed a piece of the clip and put it up on their TikTok or whatever they do today, and didn't make a whole bunch of money off of it, which is traditionally how it works, then even though someone might have done a wrong, turning that into money of significance is probably not going to happen. So
I guess if you post something, you're kind of doing it buyer beware. Someone might go ahead and snag your stuff. The positive will be you might get some exposure, some advertising, some whatever. The negative is if someone makes money off of you, chances are you're SOL.
Yeah, I mean, that's fair enough to say. I mean, I think if you want to protect it as an asset of significance that you think you can monetize, then you should register it first. Okay. If what you're doing is more in the marketing side of it, well, then maybe that's less important to you. Or even if you did register it, you're looking for the marketing push off of it. Good example. One of the rappers the other day did something on this "Let's Go Brandon" thing, right? Right or wrong, pick your politics. That person used the marketing momentum behind that phrase to propel himself into the entertainment space. And a lot of people would say, good job, again, politics aside. That's one of the ways that people can get themselves out there into an entertainment space by injecting themselves into something social going on or something newsworthy going on or whatever that might be. And how good your song is almost doesn't matter. Sometimes the worse, the better, I guess. Or maybe I'm getting old. I'm not sure.
It's all style. That's why there's 400 channels on Sirius XM. That there's talk radio and music and classic vinyl, 80s, 90s, today, #1 hits, all of these, other, all of these others out there. So one of the things that I remember from way back when I was in law school was, yeah, and you even mentioned it, using like the name, let's go Brandon or whatever it is. So what if I want to create a song and I love the Beastie Boys and I want to go ahead and grab, I don't know, 20 seconds worth of Brass Monkey and play it in my background as part of my chorus. Can I do it?
No.
How about 10 seconds?
No.
7 seconds?
A long time ago, there was some cases that went back and forth about how much is too much, and that decision came out to, if you clipped it from somebody, you took something that they arguably own. Now, if the clip that you took doesn't have any original content to it, I don't know, it's just a sound recording of someone strumming, in the key of G, whatever, something that simple, maybe not. But the things that people would clip are something identifiable. It's the riff, it's the yell, it's the whatever. And so arguably there's going to be enough of a creative element for that to be protectable, and therefore any taking is stealing.
So I guess like there's a new song out there, and I'm gonna make myself seem non-hip, but Elton John has a new song, and I forgot who it's with, but it's a very popular female artist right now. So if they're using the Elton John lyrics and Elton John's how does something like that work? Do they just record it and ask Elton John, or do they go to him first? I mean, what's the way to do it if you want to use somebody else's tracks, lyrics, music, voiceover, something? What do you do?
Okay. Well, today what we're seeing a lot of mashups and that sort of things that are out there, and so one can do a cover song, so a front to back new version of that cover song without doing any changes to it, without permission. Our copyright law allows that to happen if one pays what they call a mechanical royalty for the ability to reproduce copies of that by making your own recording. Once you want to make changes, different ballgame entirely. Okay. So you would have to contact the people that own first the musical composition. So Elton wrote with a guy named Bernie Taupin almost his whole career, and those two guys in one form or another own most of the big songs that we know by writing them. Generally, songwriters who make a significant career end up doing a deal with a publishing company, and a publishing company will put together an agreement that either the publishing company owns those copyrights and administers them for both the publishing company and the artist, or it's shared or something like that. I say all that because somebody's going to have to figure out, one, who has the rights in the song, and then two, talk to whoever that is and say, hey, we want to do a new version. Here's a fresh artist, and we want to do, every other verse in Spanish. We want to do, it's going to flip into hip hop and then flamenco. I don't know, whatever they're going to do. Can we make significant changes in the song with your permission? And if we do, who's going to own what when we come out the other side? Because the new artist won't own all of that, because it's at least a significant component of the original song and maybe even parts of the original track. And so the record companies sit down together and hopefully hash out who's going to own what percentage of what, who's going to spend what to market it and try to turn it into money. And so there's a significant amount of work that has to happen behind the scenes before anybody even goes to the studio. Unfortunately, all the time you see people come out of the studio having, put in samples and all kinds of stuff like that. And then they go to the label and say, oh yeah, that's right, we did that kind of stuff. Sorry, you guys fix that. Oh, that's expensive. And the first Marilyn Manson record I was working on, matter of fact, one of the platinums is way up there. Not for that record. When they finished, they came out with a list of the samples, and it was incredible. And they didn't tell the label. I know one of them was a guy named Charles Nelson Riley laughing. It was just his giggle. Giggle cost him like $5,000 or something, because it was already in the recording and it was sent out for mixing and mastering, and they had no choice. They had to pay the bill. And you know what? Okay, it is what it is when you ask for the check later, right?
Yeah. So if you are, so my cousin is a talented young man who's been playing music his entire life. And when I was up in New York this summer, we actually got to see him, and he was standing outside an ice cream parlor covering music.
Yeah.
Any problems with that?
No. You don't need any kind of license to stand on a corner. It's when people stand there with an iPhone and then they record it and then they put it on social media and then they try to sell a record with the live recording of, whatever on it. Those things bring on the other issues. But, him standing on the corner with his tip jar, no, go for it.
Now, let me ask you a question, because you kind of alluded to the next question that I had in mind. If he's standing on the corner with the tip jar, and my daughter was so she thought he did such a great job of a song and stood there and filmed it, and then she puts it on her YouTube account and it goes viral, but my cousin didn't pay for it, nobody's paying for it, nobody asked. Can he get in trouble for that because someone else posted it? So I guess we'll start with A. Can he get in trouble for someone else posting it?
Very unlikely.
And then if he blows up because of it, I'm guessing my 11-year-old daughter doesn't have any rights to saying I founded you, or I made you a success.
She has the rights to to tell the truth. That wow, my video got all of these likes and this person got a deal. Yay, good for them. I think if she got a whole bunch of likes, some people in her position might be saying, can I get in trouble? And that's probably a no as well, because she's not monetizing anything. It's not her project or, whatever it might be. So the worst case scenario is either there's a takedown on YouTube or something, or the owner of the copyright can say to YouTube, hey, that's my song. So if YouTube monetizes it with ads on the side, the ad money goes to songwriters. They can do that. And
how does that apply to like social media? You see it all the time: LinkedIn, Facebook, Instagram. Like, I come to your office, let's say, and I just snap a picture of the Marilyn Manson thing that you have, and such a cool meeting with John Bradley. Check this out. Could the owner of that piece of work like insist I take it down because it's on social media? And I'm not, I'm just trying to say, look, I was hanging out with a cool guy.
Well, there's a whole concept called fair use that says, hey, this image depicts, Jason and I after lunch at the office standing under the, the Clarence saxophone, whatever. And by and large, that's going to keep any of those wolves at bay. What's different, though, is, let's say I have a property with a big mural on it. Okay. If I didn't own the rights to the mural, and we brought in a real estate agent, and the real estate agent wanted to put up pictures of the house for sale, there could be a different issue there because it's not such an incidental use. Here's the big image of the big mural and blah, blah, blah. So fair use, as you might expect from my explanation, is a pretty fact by fact determination. And so, what's fair in some place might not be fair in another, but by and large, people standing around shouldn't be a copyright issue. And if it's up on your social media that your 182 friends can see, it's not of any note that would make some copyright owner hire somebody like me to go chase after it. And if it was so bad, the remedy is to take it down, not to jump up and down on any serious money.
Now, I hear it all the time, and I know you're not a real estate attorney, but this happens all the time in real estate, that some newer real estate agents, if you are listing a property, they'll go on the internet and they'll find 5 or 6 pictures of that property and they'll put it on their listing.
Yeah.
Fair use?
No.
Why not?
Well, if somebody else took the picture on that day with that lighting and that contrast and that camera and that helicopter and blah, 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 the full combination of all of those elements mean that that's, somewhat unique. And in that particular space, there's value in those things. It's not, millions of dollars, but people do that business every day. And so we see that type of lawsuit every day. Are the valuations appropriate? Well, that's for, somebody else to say. Is it worth, $100 or, $1,000? I don't know.
So I guess the smart thing is, well, it's on the internet is not a valid defense for using something.
It is not. So here's one. I represented a kid, I don't know, late teens or something, California. He gets sued by some rapper. He took an image off the net, bad, that was, I think, part of an album cover, something like that. And he had some, online manufacturer make him one phone plastic cover with the image on the back. And they did. And I don't think they even ever sent it to him, neither here nor there. But they took the image and put it on the net and then offered it to anyone else in the world that wanted to buy any kind of merch in the world that had that image on it. So rapper and company file their lawsuit, and it comes down to them suing our guy in federal court for one copy of one thing that he put on a plastic phone cover that he copied from the net.
Now, it's interesting because you hear about it all the time, and I'm going to use the real estate market. I used the picture and I was showing the place, and you get a demand letter and you take it down. Okay, I took it down. It's all good. Whatever. Case is over, right?
Yep.
Is the case over when you take it down after a cease and desist?
Maybe not. If the lawyer and the client want to be more tenacious, they say that's not enough. I want this much money, or I file a lawsuit. And maybe they do, maybe they don't. I know that it costs $400 to file a federal lawsuit, and lawyers that do that kind of work bill at least that an hour. So all of a sudden, if somebody's making a demand, I'll settle this thing for $2,000 or I'll sue you. They know that it might be cheaper than hiring a lawyer to defend them. So the economics of the game sometimes, drive the results.
So the word of advice is, to everybody that's listening, don't just grab something off the internet and think it's free use. You want to use an image, you want to use a photo, find out who owns it, get a licensing agreement. There are clearing houses that do this kind of stuff. You can do it. If you really love the image, buy it. Do it the right way. Protect yourself.
Hire somebody. Create it yourself. Do it. There's plenty of artists out there that aren't making too much money that'll be glad to do something for $250.
You probably represent a couple of those artists. So
I do, but they charge more than $250 because they got to hire me and you.
Yeah, but I mean that's the way to do it. I mean, You and I both know somebody that I worked for years ago, an attorney named Alan Fertel. He used to say it all the time. It's like a Fram oil filter. Either pay now or pay later. But at some point, get it done. Hire the attorney. Hire Mr. Bradley. Get your stuff protected. Don't walk into a studio thinking I'm going to record it and I'm going to be, the next huge star. Protect yourself. You really got to protect yourself.
That's it, Jason.
So we're almost out of time here, but usually I like to ask a question. So I'm going to ask you a fun question. Favorite musical artist and why?
I like the Counting Crows. I've seen them and done some work with them in a bunch of different places, and they're cool. That's a 30-year evolution. Big fan of Tom Petty and the Rolling Stones too. So, I got to have a pretty good time doing this along the way, and so life's been good to me so far.
Dude, and for anybody that hasn't seen your office and seen your stuff, he's got guitars and memorabilia, and I walk into that place all the time, and I'm just like, that place is so cool. One of the coolest offices, top 3 I've ever been in. We'll ignore the Boston Celtics, even though that's okay with that. But he's a Red Sox fan, and we try to avoid that kind of stuff. But I mean, guitars, and signed, and I will get back to this, because I do coach other attorneys. This is a man who truly loves what he does, and when you really, really love what you're doing, damn, that is so cool. When you love what you're doing, it is not work. And if you could go ahead and earn money doing what you love, you win every second of every day. And this man gets to play music, listen to music, help artists, help people. I mean, he is just amazing. And for any artist that is listening to this right now, including my cousin, make sure to reach out to John Bradley. If you have questions, www.bradlegal.com. You can get him on the phone as well at 954-523-6160. Look, he'll work with top talent, and he'll work with, individuals that are just getting off the ground. Just make sure to protect yourself with everything that you do. JB, always a pleasure. Thank you so much. Any last word of advice to, the up and coming artist?
Listen, if you got questions with arts, call me. If you got other questions, just ask Jason.
I appreciate you. Love you, my man. CC, as always, thank you for the goingsolomedia.com. CC, you are the best. Thank you so much for putting this together for us. And we'll be back in 2 weeks, and hopefully we hear great stories about some artists that have reached out to John Bradley. Thank you so much, everyone. Have a wonderful rest of the day.
Take care.